Could this be the reason Judge Glanville is not declaring a mistrial in the young thug RICO case? From my layman perspective, there has been many instances since this trial has been going on that I would deem cause for mistrial. In a unanimous opinion penned by Justice Robert Benham, the High Court held that Fulton County Superior Court Judge Glanville had mistakenly declared a mistrial after the jury had been seated and the murder trial of defendant Gary Otis was underway. After the jury was seated, Otis's defense attorney told jurors during opening statements that she was raising an insanity defense. This drew an objection from the Fulton County prosecutor, who told Superior Court Judge Glanville the defense had not given the state any notice of this strategy before the trial. After a hearing the next day, Glanville declared a mistrial, stating he thought the defense was required to give pretrial notice of the insanity defense. In a ruling, a unanimous state Supreme Court said Glanville was in error, and in contravention of a ruling the state High Court had released 2 decades ago. In that decision, the court said the defense is only required to give pretrial notice of an insanity defense if it planned to use expert testimony. In Otis's case, his attorney had said she was only going to rely on lay witnesses to try and prove her case. Justice Robert Benham, writing for the court, also said that Otis cannot be retried on double jeopardy grounds. We are led to believe that Judge Glanville, since ruling came down on his error in calling a mistrial in the case, he is clearly reluctant to do so in the young thug RICO case. But why, we ask? When we see many grounds for a mistrial in this case,